Today we will be discussing the research that was done partly at Radboud University, but also with participation from Leiden University and Utrecht University, with the title Consequences of COVID Crisis for the Judiciary and Vulnerable Litigants. I'm glad to welcome today two researchers that have participated in this research, Professor Marijke Voert, Professor of Empirical Legal Research at Radboud University, who was also the leader of this research project, and Associate Professor Lize Glas, Associate Professor of International European Law at Radboud University, who has led the part of the research related to fundamental rights research. Welcome, Marijke. Very glad that you could join us today. Let me first ask you, why do you think that this research is important? And what was the most interesting and surprising finding of this research?
Why is this research important? Well, it has everything to do with access to justice. And we are living in a democratic society, so access to justice is very important. And the judiciary is one of the providers for people for access to justice. So it's very important that also in times of crisis, people have access to a judge and in a procedurally right way can address their rights. So that's why this is very important. And during the pandemic, the courts were closed during a time, or when they were open, there was not enough space to address all the delayed court hearings. So they had to take all kinds of measures, the judiciary, to be able to, address access to justice for people, address access to the judiciary, and to have a hearing at the court or an online hearing. So, well, that's why our research was very important. We also addressed this question specifically to vulnerable litigants. Those are litigants, we looked at litigants involved in criminal law, prisoners. We also looked at parents who were involved in child protection measures and in, for example, refugees and migrant law. Those were specifically vulnerable litigants, so that was important that they have their day at court. And your second question was, what was the most striking finding? Well, one of the measures taken was online hearings were addressed by the courts, and it was amazing how different courts did different things. It was not that all the courts had the same standards or providing for online hearings, and they dealt with it differently. For one reason, it was because of the court building and the equipment that was available for them. But the other thing was that they had fundamental different opinions about when to use online hearings or not.
And could you give an example maybe of what was so strikingly different, and why was it, what were the consequences of these differences?
Well, for one reason, the consequences was that litigants were treated differently at different courts, and then that's not the thing you want in the judiciary. And what was different, for example, some courts, for example, in migration law, they never used online hearings in detention cases, for example, whereas others already used online hearings in detention cases before the pandemic. So they had fundamentally different feelings about what is a right hearing for a refugee, for example. Some courts thought the refugee or the asylum seeker needs to have a physical meeting with a judge always, because that's the only time a refugee meets a judge. because if you go in appeal, it's all a written procedure, so you never meet a judge at all.
Yeah, I think we're already going a little bit in my second question, which was what is, according to this research, was so problematic about the way that digital hearings were implemented during the pandemic? What were the most problematic aspects in the different areas of law that you have examined?
Yeah. Well, for example, you have to make a distinction in different kinds of digital hearings, because there were digital hearings where everybody was individually, digitally present, all individually, but there were also hybrid meetings where, for example, the judge and the public prosecutor, the lawyer were in the court building, and the prisoner was in the detention center and had to participate in a hybrid way, and only had a small vision on his screen that because the camera was wheeled into the court, and only had a very distant view of the judge, and didn't see his lawyer and couldn't contact with his lawyer. So that was one of the problems, and that was because this system was introduced because it had to be introduced in a hurry. But there were also court buildings who had already more qualitatively better equipment available, where there were cameras from all sides of the courtroom, and everybody was good into a picture for the defendant. So it was different with that kind of prospect, but what was problematic was the communication, of course, that due to technical problems, the communication with the judge was difficult. Also the communication from defendants or asylum seekers with their lawyer could be difficult. If there had to be an interpreter, that was also difficult, but because sometimes it was not easy to have interpretation, translation synchronically. Well, were more problems, but I think these were the most pronounced. That the communication between a judge and a litigant, or a judge and a prisoner, and the lawyer and the translator was complicated.
In your research, you rely a lot on the concept of perceived procedural justice. I think this has to do a lot with communication between the judge and the litigant and other participants of court hearings. Could you maybe explain what is perceived procedural justice, and how did you use this concept, and why was it important to also look into these issues in your research?
Well, theoretically, the concept of perceived procedural justice is from the social psychology, and the theory is that a procedure doesn't have to be fair on paper, but also in practice. So a litigant has to perceive that the procedural justice aspects are, he has to feel that he is respected, that he can say what he wants to say, that he is heard, and that the judge has expertise and is a neutral person, for example. And that is important because if people perceive a procedure as fair, then they also perceive the outcome or accept the outcome more, and also trust the judiciary more in the future. So that's why it's important.
Yeah. And now looking into the future, what recommendations would you draw from your research? What would you suggest for the judiciary, the Council of Judiciary, to how would you suggest to proceed with online hearings, both outside of the crisis as well as maybe in the context of the future crisis? What are the main recommendations from your research?
Well, yeah, for the judiciary, be prepared. Because they now once experienced is what it is in a hurry when you're not prepared to do those things. So be prepared, have a good plan. Secondly, look at best practices in all kinds of countries, and there are all kinds of developments to increase the quality of online hearings, all kinds of technical involvement, but also all kinds of design. Things can be introduced. Look at how people are shown on a screen. Give it a fixed order that people know who is the judge, and the judge has to wear a gown. The background has to be because now judges were participating from their home. There might be a cat jumping on the desk, for example. They didn't wear a gown. They had their own home background, so it can be professionalized in all kinds of ways. And we also think that it's better when they have a more good idea, also based on empirical legal research in different countries, for what kind of cases is an online hearing appropriate, and for what kind of cases and what kind of litigants it is not. Because for many people it might be, it has also positive aspects. Also for refugees who were, for example, abroad, were now able to join a meeting, whereas otherwise they couldn't have joined a meeting or a hearing. So, yeah.
Yeah, so would you say that in certain specific situations, actually doing digital hearings or going online can also increase access to justice as compared to the situation at the moment?
Yes, there were several examples where the online hearing increased the access to justice of certain people. For example, there were people who were afraid of going to that court, a distant court, and that huge building, and they now could participate from home. They didn't have to make costs for driving or traveling to the courtroom. So people who don't have much money might be very pleased with such kind of possibilities. There were also people who were psychologically not well and rather participated from home. So there are certain kinds of people for whom online hearings were an outcome and increased their access to justice, whereas they otherwise wouldn't have come.
Yeah, very interesting, because normally you associate the turn towards remote justice, digital hearings, more with limitations on rights. And this is something that we will talk about in our second part, I guess. Well, just me go to the last concluding question. What do you think is the future of digital justice in the Netherlands and maybe internationally as well?
Okay, I think for certain kind of cases it might have a big future. For example, in normally civil cases on trade, on professionalized parties, I think it will be a good way of solving or going to court. People or parties who are not vulnerable and have good or only lawyers are involved. I think it will be a good way to improve access to justice in this kind of way. So. And for other kinds of things, yeah, well, also some prisoners were also very fond of not having to go to court, because if they had to go to court, they have to travel and they have to wait long times in a court building somewhere in a cellar. So they were also pleased not going to court. Just maybe it depends on what parties want. I think it's important to keep that in mind.
Okay, Thank you very much. So it's not entirely pessimistic.
No, no.
Thank you. So now we're going to the second part of this vlog, a conversation with Associate Professor Lize Glas on a different part of the research, which looked into the consequences of the measures taken during COVID pandemic, in particular digital hearings, on the fundamental rights of litigants. Welcome, Lize.
Thank you.
Thank you for finding the time to join.
Sure.
Yeah, very interesting analysis indeed. Let me ask you, first of all, what were the, as I've asked Marijke as well, what were the most interesting findings of the part of the research that you've led?
Yeah, well, first of all, it was kind of hard to come up with very definitive concluding findings because we were mainly researching the right to a fair trial. And for those who know the jurisprudence of the European Court of Human Rights a bit, it's always looking at the entirety of a trial, and compensating measures can be taken. So, as is always the case, but probably for this research more than ever, very much depends on the circumstances of a specific case. But I can highlight some findings perhaps for each of the part of the law that we looked at. So for the child protection cases, these civil cases, one thing that stood out was that at the beginning, because these were very urgent cases, so these cases were decided upon. However, at the start of the pandemic, these were proceedings that were completely in writing. And this was particularly problematic for the good and the effective participation of these parents and their children, because they are usually not represented by a lawyer. So you can wonder, of course, if the decisions out of home placement, for example, they have a huge impact on their private lives. And you can wonder if these parties still have a fair trial, can participate effectively, have an actual adversarial procedure when they're not represented by a lawyer and when everything is done in writing. So that was particularly problematic for child law cases. One thing that stood out for the migration law cases was that these cases were given less priority than the other groups, but still, when they took place, they usually took place in person, or at least not in writing, or digitally. So not in writing, but digitally. And one thing that could be regarded as problematic is that they were asked to consent to a hearing being digital rather than in person, and consent should be freely given. However, you can wonder, even if you formally sign a piece of paper and say, yes, I consent, whether it was actually freely given, because if they would not have agreed, the procedure would have been a lot longer. So and that also applied to certain criminal law cases, where you can wonder whether consent is actually freely given. And for criminal law cases specifically, for pre-trial cases, you of course have the right to be brought to a judge promptly in order to revise whether, well, the imprisonment is in line with a legal ground. And in some cases, these persons were brought before a judge, but only digitally. And we think that based on the case law of the European Court of Human Rights, this should always be an in-person meeting, also in order to check whether they are being treated well physically, for example. So that was also problematic, and more in general, it was problematic, and also to some extent, of course, understandable, especially at the start of the pandemic, that these decisions weren't tailor-made. So they just applied to all sorts of migration law cases, to all sorts of criminal law cases, whereas we looked at vulnerable litigants. Of course, the extent of vulnerability differs, and this was not always taken into consideration. Also not when the pandemic had been going on for a couple of months.
Yeah, so you would say that you were able to find instances where it was very probable or highly probable that a certain right was violated.
Yeah, in individual cases, you know, not across the board. It wasn't like the core of the right to a fair trial was not respected at all, but especially when there's, for example, also many of the practical problems that Professor Voert also discussed. If you only have a video hearing of 45 minutes, if the Wi-Fi doesn't work correctly, if you can't see the judge properly, if you can't consult your lawyer confidentially because there's other people from the prison listening in, you know, adding all this up in a single case, well, that could constitute a violation of the right to a fair trial.
Very interesting, yeah. So you mentioned just before that you've looked at vulnerable litigants and that some vulnerable litigants are maybe more or less vulnerable than the others. Could you tell a little bit more about how did you approach vulnerability in your research?
Yeah, well, so we looked at both Court of Justice of the EU case law and the case law of the European Court of Human Rights, and especially in the case of the European Court of Human Rights, vulnerability is really a topic that pops up in different cases. And if it does, it has consequences for the way in which the court judges a case. So, for example, it could mean that its proportionality test is relatively strict or that it imposes positive obligations. For example, in child law cases, based on Article 8, the rights to a private life and family life, the court will impose positive obligations because it regards children as inherently vulnerable. And so this is slightly different for the other two groups that we looked at. So people involved in a criminal process aren't always vulnerable, but when they're, for example, put in prison in the trial phase, they are most usually vulnerable, especially when they are, for example, not able to speak Dutch very well. And the same applies to asylum seekers. They are regarded as vulnerable, but the extent of vulnerability differs on their specific, based on their specific personal traits.
Yeah, interesting. So you looked both inherent personal characteristics and situational characteristics of vulnerability. Did you also take into consideration that participating in a remote hearing or participating at a distance could also be situational characteristic, vulnerability characteristic?
Yeah, and mainly because it can be particularly problematic when you're vulnerable. So for example, if you need, so it's really a combination that kind of strengthens your vulnerability. So if you're an asylum seeker, which probably means that you don't understand Dutch, you need an interpreter.
Right.
And having a digital trial with an interpreter, well, that turned out to be sometimes rather problematic. So these factors kind of reinforce each other.
Interesting. So we talked about how different rights could be violated in digital hearings, but have you also found examples of where rights would have been enhanced?
Yeah, that's a difficult question for someone usually for a human rights lawyer, because we tend to look at violations rather than circumstances contributing to protecting a right. So it's a different way of thinking. But I guess that these the advantages that Professor Voert also mentioned, they're so nuanced that they don't really make a huge difference for the protection of a human right. And of course, all these rights are minimum norms. Especially when you look at the rights protected by the European Convention on Human Rights and as interpreted by the European Court of Human Rights. So they're minimum rights. So yes, it could be that the degree of protection was enhanced in rather specific cases, but it doesn't really do a lot for your legal analysis.
Right.
Because you're looking at violations and things that go below that minimum standard.
Exactly. Yeah. And what is, if you look at this normative framework from a more sort of helicopter view, what is your assessment? Is this sufficient? Does it need to be revised in the context of remote justice, digital hearings?
Based on the case law that was out there and also on the directives and stuff from the EU side, we could analyze all of the measures that had been taken rather well. And of course, the courts, when we did our research, speaking the European Court of Human Rights, had hardly adopted any judgments about this pandemic, but it had some jurisprudence about digital hearings in criminal trials, for example. So we were able to kind of use that case law and adapt it to the situation that we were looking at. And of course, all these more general notions, like including the fair trial, but also the right to an adversarial process, equality of the parties. These are all notions that you can use to analyze these processes. So I don't think you would need to elaborate the legal framework a lot. There's already a lot out there that you can adapt and use to also analyze the COVID measures. There was one judgment of the European Court of Human Rights, perhaps interesting to mention, where someone complained about the length of a procedure, and this procedure was lengthier due to, and only due to, the measures taken to fight the pandemic. And the European Court of Human Rights then said, well, if that's the only reason, that is acceptable under Article 6 ECHR.
Yeah, it's because the special circumstances for derogations from rights under Article 15 apply.
And even if a state hasn't invoked Article 15, like in the Netherlands, we didn't have a state of emergency, we did not have any formal derogations. Right. Even then, of course, the pandemic is a factor that the court will take into consideration. So we had two broader factors, really, that we took into consideration. On the one hand, vulnerability, which leads to, well, a stricter proportionality test, and then also the pandemic it was unprecedented. States did not know what to do. There was a lot of uncertainty, which unavoidably means that they have a broader margin of appreciation, so more discretion to take measures, and meaning that at least the European Court of Human Rights will not be really strict, right? There's again that minimum standard that I referred to earlier.
Yeah, very interesting. I will conclude with the same question that I asked Professor Ter Voert. What is your view on the future of remote justice in the context of a future crisis? Both practically speaking, but also from the standpoint of fundamental rights and the legal framework.
Yeah, I think that at least for the Dutch judiciary and also the government, when taking measures in the field of access to justice, they could have paid more attention to fundamental rights. I think from the start, we could have paid more attention to notions such as like vulnerability, the right to a fair trial. What do these measures do with the adversarial nature of a procedure? And also making sure that there is, of course it's really hard, but making sure that there is room to make tailor-made decisions, looking at what does an individual need, rather than saying, well, all these sorts of cases are dealt with in the same manner. So there's room for improvement, and taking these rights into account more expressly. And for that purpose, we also made a checklist for the judiciary when they want to decide whether they want to have either an in-person hearing or a digital hearing, or want to have a completely written procedure.
So on the way to more responsive law.
Yeah.